Have you been told that divorce property settlements are all about percentages? Maybe someone said to you, it's always 50-50, but is that really true? So today in this episode, we're going to be talking about what percentages actually mean in property settlement, what goes into figuring out what percentage you get, and how they get adjusted for certain circumstances. We're also going to be talking about, can you work out these percentages yourself? And why different lawyers sometimes come up with different figures, and what steps you can take after your percentages have been calculated. So if you've ever felt confused about percentages and property settlement, then this episode is going to be good for you. Welcome, Mum.
Hello, Laura. Hi, everyone. That's a big topic.
It is. I know you're very excited because you've just discovered a new case that's just been reported this month about property and percentages, and another, it does touch on wastage. So we're going to talk all about that. So anyone who's already in the court, this is going to be helpful for you as well. Because as we all know, there's been changes to property in the law world since the 10th of June. But before we get started, I'm just going to do a quick disclaimer that Mum is not your lawyer. I am not a lawyer. We are just doing a discussion about property percentages. Please go and get your own independent legal advice, as every situation is different. We may also touch on family violence or coercive control. So if you feel that you will be triggered by that, please be mindful of that. You can call 1-800-RESPECT if you're experiencing family violence, and you can also call 13 11 14 Lifeline if you are feeling distressed. So let's get to the jingle and let's get started.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Mum, let's go basic 101 for any of our newbies who are listening today, and then let's get into the nitty-gritty. So percentages, when you're getting separated, I guess you're splitting everything, and you've got to figure out how much of the cake are you going to walk away with and how much of the cake am I going to walk away with. Is that pretty much what percentages are?
That's exactly it.
Okay.
Yeah. Oh, and also whether you get the cake with the extra bit of icing on it or the other person gets the cake with more fruit in it. I don't know. But essentially it's dividing up the cake.
Okay. And people who don't go to court, who just want to do this themselves, why do they need to be aware of what the court does? Why does it matter to them? And why do they need to know what the court does when breaking up property if they're not intending to go to court?
Well, for two reasons. One is that all negotiations are conducted basically under the canopy or the umbrella of what would the court say. That's the only reason people negotiate. Otherwise, they might not bother. If someone's got the whole house in their name, why would they bother negotiating? But everyone knows what the court might do, and therefore they negotiate under that. The second reason is that if you don't know what the court will do, and if you don't divide the property according to the court's rules, then it could come back and be overturned later on. Even if you're doing like a binding financial agreement, which isn't binding, even if you're doing that, you really need to know what the property pool is and what a court would do so that you know what you're giving up in your negotiations.
Right. So if anyone's listening and they don't intend to go to court, they're amicable or it's not a worry, they're like, why should I listen to this? Why should I care about what the court would do? It's so that, particularly if you file in the court to make it official, that's the court giving it the stamp. So saying there's drawing a line in the sand saying you're done, your property's separated, you're done. A court might not agree to your agreement. Is that right?
Yeah, that's right. If you're wanting to file consent orders where you're saying to the court, hey, I want to invoke your jurisdiction and here's our application. By the way, these are the orders we want. That's what a consent order is. The court must not make an order unless it is just and equitable. It used to say, I think it used to say may, but it must not now. So you're not going to get that rubber stamp unless what you've agreed to in your consent orders is roughly in alignment with what you would get when you went to court. Or if it's not, that your covering letter talking about the justice and equity of the case will explain why it's not close to what the court might order in the first instance.
Why isn't it just 50-50? The question I was supposed to ask is property settlement always 50-50 split? And everyone should know by now that is not the case. So why isn't property settlement always 50-50 split?
Some countries it almost is, right? They have community property and they just divide it, right? Some countries do that, but we don't. Australia doesn't. And that's because the different factors that are set out in the Family Law Act, so the court looks at things like looking at Section 79.5 and 79.6, we're looking at contributions, financial, non-financial, before, during and after the marriage. We're looking at your contribution as a parent and homemaker. Then the court looks at future needs of people and what they will need to go forward if we divide based on contributions. Say you did contribute 50-50, right? Everything we've got, we were 50-50. The court goes, yeah, but hang on a minute. Let's have a look at Section 79.6 and look at 90 SM, and we look at and say, all right, well, if we leave on contributions in 10 years' time, this person's going to be worse off than the other person. And so they try to increase a person's percentage so that going forward, it's fair, it's just and equitable.
Right, and the new term for that, it used to be future needs, and now it's future and current circumstances. That's what they're looking at. Current and future.
Yeah, current and future circumstances. Right. That's right. So there's a heap of factors. It's probably altogether 15 different things they look at, the court looks at. And then the magic one is Section 79.50, which is, I'm just looking here, and it's basically the every player wins a prize. It's the any other fact or circumstance that the court considers it should take into account. So there are so many things that get taken into account. I think it's Jurek. In that, the court said basically, look, we all understand it. It's 50-50 or thereabouts is kind of the starting point. And then I think, but it's not set in law anywhere, okay? And so what we're saying is like, it's the vibe. It's the vibe.
So basically, most lawyers, when looking at this, go, okay, let's just start off as 50-50. And then adjust based on all the other circumstances.
Yeah.
Can you just list off some of the main current and future circumstances that are really, that you see mostly looked at so that people have an idea of what kind of things the court would look at?
Yeah, sure.
Look at?
In fact, I've got them
Perfect.
here. But yeah. First, like I said, it's two lots of contributions, financial and non-financial, and you divide those through 3 periods of the relationship. Financial, non-financial before you got together. Usually that's just financial if someone owns a house or part of a house. Financial and non-financial during the relationship, and then financial and non-financial since separation. So that's the paradigm. That's the top 6 in terms of contributions. Then they look at current and future circumstances, Section 79.5, and for that the court is to take into account. So that's almost like a command to the court. It doesn't say may, it said is to take into account the following considerations as far as they're relevant. And then it rattles off things like age and state of the health of the parties, whether there's been family violence, who's got to look a legal obligation to look after someone over the age of 18, whether either of you has perhaps an overseas pension or something, the extent to which you contributed to the other person's earning capacity, like if you worked full-time while they studied and now they're a doctor or whatever, and that is a contribution. They're looking at any debts that the people have incurred during and after the separation, and that's a new one, that kind of wastage argument, and then the commitments necessary for them to maintain themselves. And another new one is whether or not someone who's going to have the care of children needs to be able to house those children, and the court will look at that. So they are really looking at the extent to which the interests of the property would enable, like if they changed the property, would enable a person to undertake some education or establish a business. So they are really getting quite granular into these people's lives. What are you going to do if you get the house? Or if you get an extra bit of money because you're going to be studying, are you going to make money at the end of that time? So they just balance all of that up and down and come out with an answer, which is why you can't do 50-50.
I like that you didn't mention income at all at any point in that bit there. So
it's there.
But that's that's future and current circumstances. Because we hear of people getting letters from lawyers with a list of all the pay slips that their ex has received in the last 10 years of the marriage, and it's my client earned over $1 million in the last 20 years of the marriage. Your client earned $2. So therefore, my client deserves most of the property pool. We hear that a lot.
We do, don't we? And it doesn't apply. It doesn't apply.
When does income matter then?
It matters going into the future if there's a big disparity with the property settlement, with your income going forward. In the relationship, those earnings and going to work every day are offset by either homemaker contributions by the parent, by the other person, or if they're a stay-at-home parent, their contribution in raising the children. Sometimes it's agreed between the parties that one of them should stay home. Maybe one person's career, if you're a prime minister, for instance, one person's career is so absorbing of everyone else that your partner can't work. You can't work. So income doesn't count as a property contribution, right? Wages don't count as a property contribution unless it's a redundancy, comes in a big lump, unless it's share dividends that come in a big lump, but not your monthly. And I always use the same analogy, and all our listeners will know this, whether you're a neurologist or a brain surgeon at a hospital and your ex is a cleaner, it doesn't matter. If you both worked, contributed to the relationship, you've done your best, and there's no sort of waiting for that.
I think we've got an episode on the hidden contributions, and we talk about the role of the homemaker or the primary carer, whether you've got kids or not, you may have been the homemaker, and how that factors in. So go and listen to that episode if someone's been throwing that argument at you recently. Okay, so there's all these factors to consider, and we've done an episode recently on wastage. Yes. And if you want to go listen to that episode, go listen to that if your ex is wasting things. And we had a question in the Q&A, and it was, how do you figure out how much of a percentage you adjust for each of these factors? And they were wanting to know if there were any cases. And you've done some sleuthing and you've found one that you want to share with everyone today. But can you just give us a brief ballpark understanding before we go into that? How do you figure out how much to adjust for your future and current and future circumstances, some sort of factor? How do you adjust the percentage?
It's tricky. In my mind's eye, it's like a set of legal scales. I'm assuming you've adjusted for contributions, but if you haven't, let's just say we're starting out in doing it. So, all right, what if at the beginning of the relationship, one person had 80% of the property? They owned a house and a car, and the other person maybe had a car. Okay, so 80-20. Then they've been married for only 2 years or 3 years. That length of time is not going to really alter that percentage by much, or if they were together, not just married, but together. And it might be that it's an 80-20 split of assets, in which case each of you might walk away with what you've got. But that changes. That 80-20 changes, say, if there was a child, or if the marriage or relationship was 20 years long. So your 80-20 goes down and down, not because it's eroded, although that's what we all thought we would say about it, but because the other person's contributions begin to match yours. They don't have to exceed, they just have to begin to match yours. So Judge A might look at that and go, okay, 23 years married with a child who's going to live primarily with the person who didn't have the money at the start. That 80-20 might go down to 50-50 because there might be a 10% adjustment because the kids are 9, right? And if the property pool's $1 million, that 10% is only $100,000. But they might say, okay, so we're going to adjust it by that 10% because you've got the children and going forward. And then if your earning disparity is great, like between, say, one person's earning $300,000, one person's earning $60,000, then maybe going forward, there will have to be an adjustment to help the person with the lower amount to educate themselves. That's all based, say, on $1 million property pool. Those sorts of things might happen. Judge B might find it slightly different. But the reality is the court actually looks at the reality of the situation. So if your entire property pool, for instance, is $500,000 and you fit under the priority property pool, for instance, then 10% is only $50,000. and 20%'s $100,000. And that's not much, particularly if one of the parties is earning that much every year. And so the court may then want to do it in a more, they might give a person a much higher percentage if the dollars that they're dividing are low. So they've got to look at the practical effect of their orders.
Okay, so they look at these current and future circumstances. They look at the contributions before, during, and after. They look at the length of the marriage or the relationship. They look at whether there's kids. Then they may, in their head, come up with a percentage, but then they look at the practicality of that, and they look at how big the property pool is and adjusting it by 10% if it's $1 million as opposed to adjusting it by 10% if it's $1 billion. The difference would be bigger. So if it was $1 billion and they were going to do the adjustment for the same thing, maybe the 10% would be 20% as opposed. Is that kind of?
That's right. That's right. They're looking at the actual, they do it in percentages, but they look at the actual results in dollars. But then remember I made that lame thing about different fruit in one slice of cake or more icing on another slice of cake. The court also has as another kind of moving part, like a kind of Rubik's Cube moving part. They have to decide how much of the property that a person gets is going to be superannuation or of non-superannuation assets. Okay, and so that's another moving part.
It's not written anywhere, is it?
It is. It is. I mean, it's in Section 79.5, all of those things, and then all the case law. When I started in family law, it was 1984, right? And the Family Law Act was 9 years old. There were about 9 books you had to have with the cases in it and a very small volume of the Act. Over the years, there have been more and more cases developed, and there's always leading cases.
Do you want to share this case with us that talks about percentage adjustments?
Yes, I will. In this one, this is called Shaman, SHAMON, 2025 case. And it was a full court. Justices Maguire, Ismail and Curran heard the appeal. There were 3 kids, 17, 14 and 7, and it was a 16-year marriage. The husband was an accountant, 46, wife was 41. She's a stay-at-home mum. He was an accountant. And he'd been up to all sorts of tricks leading up to the trial. Okay, he had withdrawn from the property mortgage account. He had declared some dividends and therefore there was a debt owing to the tax department. He made a payment to his sister and he basically said, well, that's all gone then. There's not much left, except if it was, I don't know what he nicked. I think it was about 1.4 million. But the net pool, what was left was 1.74, okay? And so the court said the contributions were 55% in her favour and 45% to him. And then they said there should be an adjustment to her of this remaining property pool of 20% under Section 79.50, which is the any other fact or circumstance the justice of the case requires to be taken into account. And he appealed. And he said you should have taken into account capital gains tax. You should have taken into account the tax on my income that we hadn't paid. Okay. And the court said, look, we know they should have taken into account the tax, right, because that was money earned during the relationship. But as for the rest, they found, no, it's pretty good. And the fact that he had to sell the house to pay her is as a result of him disappearing all that other money, so he had to wear it. But this is the first case I've seen where we've got an inkling of how the court's going to treat wastage, and it is an inkling of how Shinohara is going to be interpreted.
All right, well,
forward.
let's talk about that in a minute. But just to summarise, so that case, basically, the judge said, because you've been a naughty so-and-so, and there is no naughty so-and-so section in the Act, so they've just put it under other relevant factors.
Yes.
They gave her an uptick in percentage. So what percentage did she end up getting?
Yes, she ended up getting 20% increase over him, even though the kid's 17 is only 1 year short of being out of consideration. 14 is only 4 years, and 7.
So what was the total percentage?
She ended up with 55 and 20. So she ended up with 75%.
Okay, and then he appealed.
Of the property pool. He appealed.
And the judge and the appeal court said nah. And so because he's appealed, it's now become a case that people can refer to.
That's right. You could refer to it if it was just the single judge, but this gives it much more authority when three judges have a full court's made this argument, and it's binding on all of the lower.
So we hear of so many nasty exes, and particularly accountants or lawyers, ex-lawyers or accountants.
Can I wag my finger at self-employed business?
Yes, and they do these nasty things where they give their money to a relative. They all of a sudden have this massive tax debt or this capital gains debt. And all of a sudden the property pool's gone from 5 million to 1 million, or it's gone from just 1 million to 500,000. So you're saying that this new case is a good indication that the judges are going to have to pay attention to the shenanigans and potentially give a percentage uptick.
Yeah. So they found that there was no error in the trial judge. Okay. And so his premature distributions were 1.358 million.
Right.
And so the court gave her 25% extra of the property pool, which ended up with her, I think, getting almost all of the pool anyway.
So she got pretty much everything because he'd already taken as much.
She got pretty well. That's right. She got 75% of the 1.7 that was left.
Okay.
Yeah. And the full court sort of said that was fine. There was no error in that. So that's going to be a leading case going forward.
Right.
And I'm really happy about it, actually.
Right.
Because add-backs were notoriously difficult to prove.
So let's talk about that. So Shinohara came out, and we've also been hearing this new case where they said no more add-backs. We're not doing add-backs. This new case said we're going to just, add-backs are dead. This new case, it's showing that they will adjust, like you said they would. You were right. They will adjust the percentage. Because we're getting letters from, other people are getting letters from lawyers saying, I know because of Shinohara, there is no such thing as add-backs anymore. So that's wrong.
I've said that from the beginning. A proper reading of Shinohara was not that you would never get any account taken of the money wasted. All Shinohara said is don't put it in the balance sheet. And so these people have put in the balance sheet only the stuff that actually existed at the time, 1.740 million. But he didn't get away with what he'd taken out, or it wasn't an add back as such, but they listed it on the side, and the court goes, so he's got that, or he did this, so therefore we're going to divide this existing pool more to her as a result of it. So where add backs were tricky to prove in the past, and then the court may or may not have taken them into account, the court is now looking at wastage, which is another word for it, I guess, and the court is now looking at the effect of that, what the dollar value of that is, and then they're able now to make an order that compensates the person.
Okay. Now, your answer to this question may be slightly different to what it was before the changes, but if you went to your lawyer with all of the property pool, with a list of your contributions before, during and after the marriage or de facto relationship, and pointing out current and future circumstances, a lawyer should be able to give you a percentage, right? A rough percentage of what you should be going for. But if your ex goes to their lawyer, is their lawyer likely to come up with the same percentage that your lawyer is going to come up with? Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today. But if your ex goes to their lawyer, is their lawyer likely to come up with the same percentage that your lawyer is going to come up with?
I would think so. If they're good family lawyers, there should be no more than 10%, 5-10% difference. But it's garbage in, garbage out, Laura. You have to know that their lawyer, he's telling or she's telling their lawyer all of the facts that you're telling your lawyer, and that each of you is being honest. So sometimes they might go to the lawyer and get some advice and come back and tell you about, I'm going to get this much of the property pool. But it's probably, if your answer's different, it's probably because of the different inputs to the lawyers.
Right.
Sure, some lawyers don't necessarily know all the law, but generally it should be just the quality of what information has been given, and then maybe they will go in favour of their client a bit when they're looking at ranges, and your lawyer might go in favour of you a bit when they're looking at ranges. That's just human nature. And a judge will go somewhere around there usually.
Okay. And it's really who argues better. So if you're not going to court,
hang on a minute. Come back. I'm not letting you get away with that.
Yeah, but really, if you're in front of a judge, it's who's got the most evidence to argue this.
It's the proof. It's the proof, not the argue. It's the preparation of your case and the proof.
Okay. Yes. But if you aren't going to court, if you're not going to court, you're going to mediation, or you're negotiating with your ex via letters. How do you get that information into their head? You're wrong. This is actually what I would be likely to get in court. So this is what I would like to go for. Like, how do people do that?
All right. So as a lawyer, if I went to a mediation with a client, I would have the law there to show them, and hopefully the other lawyer knows. If they aren't perhaps up to speed with the cases, I might even refer them to a case or bring a copy of the case. When you go to mediation, people who've done our course, and hopefully our listeners know, if you take a chronology and you take your draft orders and you take a little statement, a little submissions, right, of why you think what you think, and it's in writing, and you've got a copy and hard copy for the mediator if they're in the same room, copy for the other person, that shapes the whole narrative of the case. So I try to anticipate what they're going to argue and have my rebuttal there. And another thing, if you can't find evidence to support your argument, have a look for evidence that supports theirs, because sometimes, and I'm saying this to anyone, but including lawyers, including myself, sometimes we're wrong. Okay? If you can't find a case or evidence in the Act for your basic claims, well, then maybe it's wrong and maybe they're right. But if everyone's stuck to looking for cases, looking at the law, it should be a smooth issue. Of course, there's personalities, hey, Laura.
So I guess that when those people get those income ones, this is how much income your ex earned in the 20-year marriage, you could write back and go, what case are you relying on for that argument?
Yes, because it's not, and there's equalisation of super, which is poppycock as well. There's no case law.
Do you want to go listen to that? Why Mum says equalisation of super is stupid and dumb and not case law. Go and listen to that episode. I'll put that in the show notes. Great news that wastage is going to be a thing. And if anyone's got an ex who's being a sneaky little so-and-so doing this kind of stuff, you could probably, I would strongly suggest go read that case and give it to your lawyer or have it in mediation to show to them to stop them from doing that. Because if they realise it's going to bite them in the butt, they might not do it.
Well, yeah, sometimes people, they get a hold of like a case like Shinohara and they quote it all over the place. So when it's like playing or cards, so they put Shinohara down and you can slap Shaman right on top of it and say, but.
Well, that's good. It's like playing, Can people work out percentages themselves?
Well, in our course, we've got a system and it's not too bad, and mostly they come out of roughly right. But lawyers should be able to help you better work out percentages, because I just pointed out how things might be different. If it was a small property pool, the percentages would be different. And also the court might give more emphasis to one fact, like a person may be ill and they might think that warrants a 10, 20% adjustment in their favour, again, depending on the size of the pool. So going back to my scales, this person's got a higher income, this person's got a lower income, so they stay up, this one stays down. And this person's got the care of the children, right? So their percentages go up. It might be that someone's really ill, like I said, and that might be more money to the ill person. Trying to explain it like that, I guess. More money if you've got the kids. Each of those factors gives you a percentage. Each of those factors depends on the property pool total and what the real effect of it is.
So I guess if you're looking to try and do a lot of this yourself without using lawyers too much, you could go and look at the section of the Act of the factors that they consider.
Mm-hmm.
What's the Act again, Mum? What section?
Section 79, 4 and 5. And if it's a de facto relationship, Section 90 SM.
Okay. And I guess educating yourself on those factors and trying to figure out where you fall into that. And then, like you said, like you mentioned, Mum, people in our course do it. We have spreadsheets and we walk you through it. But you could try and figure it out and go and see a lawyer and get them to support you through that as well.
Yeah. You can't just assign 5% to everything and think that'll be right.
Because I do think it is, if people have had most people don't have anything to do with divorce until it happens to them.
No.
But some people have
You don't plan for it.
And a lot of people immediately just go, okay, I agree to 50-50. I don't want to have a fight with you. Let's be amicable. Let's do 50-50. So it seems to be stuck in the brains of people. And Mum, I just want you to reiterate to any of those people whose exes have made them agree verbally to 50-50. Let's not use lawyers. Let's not go to court. Let's just get 50-50. What do you say to those people?
I say to them, look, you cut an apple in half. That's not fair if it's not half, but that's not how the law operates. If you have agreed to 50-50 in a moment of guilt or just to get out the door or for the sake of peace or whatever, you aren't stuck with that. If you verbally agreed to that, you're not stuck with that. You're also not stuck with not getting lawyers. You're also not stuck with not getting super.
Yeah.
You're entitled, you're just as entitled as any other human being in Australia to have a fair adjustment of property to you, and any promises that wrung out of you under duress or that you've just on the spur of the moment without legal advice agreed to. As long as you haven't gone and put them in orders, you're quite entitled to change your mind.
Now, before we talk about what's next after you figure out your percentages, I think it's really important to point out that we have done an episode on percentage pitfalls. And
yes,
Mum, would you like to explain this problem? Because people figure out their percentage and then they start just saying it on repeat to their ex. And what are the risks of even raising percentages with your ex to start with?
Well, I worry if you get percentages agreed first, then the whole argument becomes, what is this worth and whose shares that?
So if your ex and you sit down, you've figured out the percentage based on the current and future circumstances and contributions, and you say, okay, you're going to get 60%, I'm going to get 40%. The next question is, of what? 40% of what? And you did some examples today in our Q&A, Mum, where if you're getting 20% of the property pool and your ex is getting 80% of the property pool and you're trying to get the house ready for sale, you're not going to care as much as you would because you're only going to get 20% out of the house potentially. Or you're going to hold out and wait for the highest offer you can get because you're only going to get 20% out of it. And that's one situation.
That's only one pitfall
from selling the house.
Yeah,
but then the other pitfalls are what, Mum?
Well, so first of all, don't work out percentages with your husband or wife. Don't tell them what you're thinking. Think of it in concrete terms. Otherwise, the debate is, okay, so I want that painting as part of my share, but it's only worth $20,000 or it's only worth $400. And the other person goes, hang on a minute, that's worth lots more than that. So each of you wants your 50% to include stuff that you really, really value. And you try to enter into shenanigans about whose bedside table's worth more than the other person's bedside table. And all of that, you end up in a furniture fight.
You end up in evaluation fights.
You do. And you can't walk it back either. If a person's committed to a 50-50 or if they've heard you say it, you can walk, like I said, you can change your mind, but it's very hard for the other person to let go of the idea that 50-50 was, I worry about 50-50.
It's better to argue not in a percentage term, but in a factual term. Okay, so I'm going to get the car, the house, this and that, or I'm going to think I should roughly get figure out how much the property pool is, and I think I should get this dollar amount.
Yeah. You work out that dollar amount. If you've worked out 50-50, right, you can list everything down and think, if I take this as part of my 50, this, and they get this. And then just write a list with dot points. Here's my proposal. You get that. I get this. What do you think? And the other person will have in their mind a way of working it out and a different percentage thing. And your percentages may never match. So often when we try to tell the judge will go, and what percentage of the property pool is this distribution, please, when we've reached agreement? And invariably, one lawyer will go, well, Your Honour, on my client's case, it's a 50-50 split. On my colleague's client's case, it's a 60-40 split. You call it what you like. It's the things that matter. It's the actuals that matter.
Instead of giving it the label, like Mum said, you write the assets on either side. You get the car, you get the collection of wine, and you get this much cash. I'm going to get this painting and this caravan and this much cash, which will cause a whole lot less arguments than saying, I'm going to get 60% of the property pool. So, Mum, once people have figured out their percentage, what's the next step?
Well, I guess the next step is to apply that to the property pool. So, like in this lady's case, the net pool was 1.7, million. And so if she was hoping for 50%, for instance, it'd be $850,000. And then I write down that amount of money, and then I start taking off the things that I know my client's going to keep. Their car, keeping the caravan, and I see what's left that has to come from the other side.
Okay.
And say the person in a separation, if a person wants to keep the whole house, like the house is generally the biggest asset, they're going to usually have to pay money over to the other person in order to do that, or they're going to have to give everything pretty well else to the other party to achieve that. So, and then what you're arguing about then when you go to your ex with those proposals is that they can see what they're fighting over. I don't want that painting. It's not worth that much. Well, let's sell it and we'll divide those proceeds. That sort of thing. But it's less emotional.
So the next steps, I guess, is figuring that out and then negotiating. So either that's writing a letter to your ex, stating what you want, or making the offers, as long as you've seen a lawyer before you make an offer. And if they don't agree, inviting them to go to mediation. They are the next steps, really. And in mediation, Mum, do they just sit down and just nut it out?
Well, you have a mediator who facilitates the agreement, and they can carry messages backwards and forwards between you both. And they take some of the heat out of it, and they can do some reality checking and find out what people really want. You may never understand why your ex is fighting so hard for the caravan, but they may tell the mediator and tell them they can tell you that actually your ex is planning to travel around Australia, so they're prepared. That's why they want it. That kind of underlying thing.
So if anyone is wondering, it's great that we've got that new case that talks about wastage and how they've adjusted the percentage for that. But Mum, today in the Q&A, you were telling our members someone was trying to find cases that had different percentage splits, and you explained to them to do what?
Well, I said to them that there's like thousands and thousands of cases now, and not every case is going to be binding. So we have what they're called leading cases. That case I just read to you, then Rosati was about the capital gains. That was 1998, and they quoted it in September of this year. So, cases stick around. Some are more important than others. What you should do, in the case of Shaman, for instance, if you Google that.
I'll put the link in the show notes, but
yes. When you open up the case, you will see on the right-hand side, you'll see Law Site, LAWCIT, and click on that, and you will see all of the cases that have recently mentioned this case. Right. Okay? And that you can go down that rabbit hole and see what the thing. But basically, the cases that really matter are high court cases. We haven't had any yet for these new changes, or full court cases, because each court is binding on a court underneath it. So the full court can't make a finding different to what the high court has made on something, and the lower judges, most of the ones we're seeing, they can't make a decision contrary to what the full court has said. Otherwise, they're open for appeal.
And people should be looking for cases about the certain factors they're arguing, not a percentage split, because it might be completely irrelevant to yours. If you're wanting 80-20% split, someone's 80-20% split may have been for completely different reasons. So you want to be looking for cases that are related. So, Mum, what was the domestic violence case that the lady got a more percentage?
That was Dani and Dajani. and she got a higher percentage as a result of the family violence that occurred during the...
That's another case that you could look at.
That was February this year.
We'll put that link in the show notes. So if you've got a specific factor that you're looking at and you're like, well, that's relevant to me, I think I should get an uptick in that. You could go and look at the cases that talk about that factor.
Yes. And if you've got a recent case, like Shaman, for instance, when you open that up and go into law site, you'll see all the cases that they refer to and that they considered. And they're all hyperlinked. Okay. So you can do a deep dive. It's not the case that every single factor is going to be the same. Like the percentages aren't going to be the same just because it's similar in fact. We had a case last year where they thought they were exactly on point for Stanford, which meant the case wasn't eligible, shouldn't have been heard. There was no order to be made. But although it looked like the same, it had different factors. And that's why I guess we do so much talking about law and why family law is so tricky, because there's a lot goes into each of those factors.
Right. And we do have some episodes that we did way, way back many centuries ago in the early stages talking about these, but some of them have changed now. So be mindful of that. But future and current overall, your contributions before, during and after, and that's financial or non-financial contributions. And then they're looking at your current and future parenting circumstances. And you can learn more about that in our podcast. You can go and, you can't do the course at the moment, but the course is available from time to time for intake, and you can do that in the course as well. But you can try and get your head around it a little bit before you go and see a lawyer. And it does sound really pie in the sky, but I think the best thing for people to know is that you don't have to go to court, but you can use the court findings as your argument in mediation. Mum, is there anything before we go when it comes to percentages with amicable that people should be worried about?
I think with percentages with amicable, just even though you're friendly, just go and check, okay? Make sure it's not just that you're not giving up too much.
Okay.
All right.
And I think even with amicable, I'm going to say I still wouldn't be saying the percentage. I would be saying this assets, I want these assets, you have those assets, as opposed to a percentage, because that could cause problems. When it comes to avoidant mother, anything about percentages?
Yes. Again, they may not care much about percentages, but they may want the house or whatever it is that's least trouble for them. And they might not want to take over a mortgage, and you do. So just tailor your proposal to them that matches their propensity to what they're going to do or not going to do in the future.
Yep. Okay. And then high conflict?
High conflict is hard to mediate with, of course, because they're going to argue everything. For all of these personality types, though, Rosie, we have to remember how much legal fees are and how long it might take to get a judgment. And when you're working out percentages, sticking to your guns, when you're thinking of arguing a point and sticking to your guns, just do a reality check and see, okay, we're 3% apart. What is that in terms of the entire property pool? Oh, it's about $90,000, say, right? Oh, it'll cost us more than that to go to court. So then you can make a commercial decision. High conflict people struggle with that. But you should always keep in mind that standing on your principles is silly if you're going to spend that much in court anyway. Plus, you get the bonus of 12 months or more of stress and agony and uncertainty and delay.
Yeah, and we have a good episode on deciding whether to settle or go to court, and we talk about all the considerations. So go and listen to that episode. Yep. I guess also having cases, like you said, Mum, at the start, printing them out, taking them with you, educating the other person
or their lawyer.
And then so that the high conflict, they don't really have a choice but to agree to the facts. And chronologies, like you said, Mum, have worked really well for our members and yourself in things where they can see, oh, okay, on this date, this happened, on this date, this happened. Oh, okay, that makes sense. When it comes to manipulative and controlling, though, when it comes to percentages, I guess we've already talked about this pitfall in particular is don't mention a percentage because they're the ones that are going to try and run down the value of things or argue that one thing's worth way more than it is because you want it so that they get more of the property. Anything else, Mum?
You've got to work out whether standing on your digs is worth it. And if you go to court, a manipulative and controlling person is going to be a lot harder to go to court with.
But that new case,
I know. I'd be sending that over.
If you're going to do manipulative things with our property, here's what happened to this person.
Yeah. Do you know what? I reckon that might have an impact as it filters down to people so that the general public is aware of it. Then I think you'll find a lot of this stuff will stop. Because what if this bloke in Shaman actually did give the money away to his sister and can't get it back?
Yeah, it just ends up.
That's tough, really.
So be strategic. If you're with a manipulative and controlling ex, be strategic. Keep your cards close to your chest. Don't give them too much information on the reasons why you want things, I guess, to start with. Try and get the help in mediation. Try and have those cases there, and hopefully you won't need to go to court.
In your high conflict cases or manipulative and controlling cases, try not to give them little bits at a time that they want. If you can do it without compromising your own integrity in the court, if they want to come around and pick up this, want to come around and pick up that, or they want to transfer the cars now, I wouldn't do that necessarily because they will whittle away the stuff that they want and then they've got no reason to negotiate. So I would be kind of trying to keep them on a string.
And saying, no, I don't want to negotiate until it's all negotiated. I don't want to agree till we have a full agreement. Because you do see that, don't you, Mum? Where I just want to take this car and put it into my name. And then they set themselves up so they're sitting pretty. And then there's no reason for them to negotiate. And then you're stressing out. So
you'll have to go to court. Yeah, that's right.
You've got to find their pain point.
I like that. Yeah, find their pain.
Well, if you liked that episode, please make sure you let us know in the comments, like and subscribe. We've got one more episode to go before we choose our lucky commenter or reviewer who gets to have a chat with Mum.
Mm-hmm.
So this is your last opportunity to rate, review or subscribe and comment on us on Spotify, Apple or YouTube. And we'll be choosing one of those lucky people next week to have a free chat with Mum. So thank you, Mum, again for sharing all your valuable information. This is good news for those with post-separation abuse exes. I think that case is going to be pretty helpful for some people. And we will see you all back next week. Thank you, Mum.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.